Kalimera σας. Good morning. Sabah al-Khair. Now it's time to move to the third session. The third session of the conference, of this international conference, is dedicated to the exercise of religious freedom and other cultural rights of Muslims. And our first speaker is Professor Agustin Motilla de la Calle from the Public University of Madrid, Carlos III. Please.
Thank you, Mrs. Chairman. The title and the aim of this presentation aims to summarize national reports on religious freedom and cultural rights of Muslims in Europe. Some way, it synthesizes the multiple aspects that the presence of Islamic religion affects Europe. In fact, it would not be an exaggeration to affirm that the dialectic Islam-European society is one of the main problems the religious phenomenon presents in the current century. Proof of this is the frequency with which this issue has been the object of study and debate and the Consortium's meetings, directly in Vienna, 2001, and this of Thesaloniki, and indirectly in Madrid, 2009, on migration, and Tallinn, 2017, on security and religious freedom. All of this indicates that the multiple points of view regarding Islam, beyond its nature as a monotheistic religion with different traditions and cultures, is very important. Let me point out three of these dimensions that have a relevant impact on the subject being studied, religious freedom, as we will see here. First, in most countries of the European Union, and leaving aside the secular existence of minorities of Muslims of Turkish origin in Greece and Bulgaria, or Tatar origin in Poland, Lithuania, and Finland, Islam is the majority religion of the immigrants who arrived from Islamic states in the 60s and 70s, for example, in Germany, and mostly in Great Britain and France, or 80s and 90s in the rest of the countries. Their different customs, difficulties in using the country's language, or the situation of poverty and marginalization have made their social integration more difficult. They are seen as different, strange people. Secondly, there is the tendency of conservative Islam towards fundamentalism and theocracy, present in the proliferating Salafi religious movements, and also in the politics of states of such international weight as Saudi Arabia in Sunnism and Iran among the Shiites. And thirdly, we can see the desire of certain Islamic states to control their nationals abroad and use them, if necessary, in the foreign policy as a tool to create pressure. The cases of Morocco in relation to Spain, and we remember the recent invasion of children and adolescents in Ceuta, allowed by the Moroccan government in retaliation for Spain's permitting a leader of the Polisario Front to be treated in Spanish hospitals. And also Turkey, through the public institution of Diyanet, very active in countries like Germany or Bulgaria. These are paradigmatic cases, to which is added the policy of diffusion of fundamentalist Islam through the spread of the so-called petrodollars practiced by Saudi Arabia and the other countries of the Persian Gulf. Certainly, Islam in Europe is much more than a religion. We have indeed the dogmatic content of a monotheistic, perhaps little evolved religion that constitutes an authentic felt and shown. Morals, traditions, law, everything inspires the being and the actions of the Ummah or community of believers. However, as I said, added to the dogmatic aspects of the religion is the condition of many Muslims as immigrants whose social, legal, and economic position leads them to marginalization. the fundamentalist drift of this religion, and the desire of dictatorial or authoritarian states such as Saudi Arabia, Turkey, or Morocco to influence the internal politics of European states through their nationals. Faced with this situation, what type of response have the different European states adopted? Logically, the answer depends on the sociological composition of Muslims in each country. There are a great variety of situations referred to by national reports, but they could be classified into 4 different groups. First place, those states with very little Islamic immigration. They have a low percentage of it, very recently arrived in the country, particularly through the policy of reassignment among states of immigrants fleeing the armed conflicts in Syria or Yemen. Czech Republic or Sweden could be examples of this group. Second place, countries in which an historical Islamic minority coexists with recent Muslim immigrants. Finland or Lithuania Tatars were members of the Soviet or Russian occupation armies. Or in Greece, Hungary, and Bulgaria, Turks settled during the long rule of the Caliphate on both. It should be noted that following the national reports, in these countries, the historical Islamic minority is in general well integrated. They have a legal status that guarantees their rights and freedoms and does not constitute an element of social or political conflict, which could indicate that perhaps Islam as a religion is not a problem. In third place, states that without having a significant minority of Muslims throughout their history, either because they never had Muslims or because they expelled them, this is the case of Spain in the 7th century, received mainly during the 60s and 70s, like Germany and Belgium, or the 80s and 90s in Italy and Spain, a large number of Islamic immigrants from Turkey, Morocco, or more recently from the Middle East of sub-Saharan countries. This situation leads to serious problems of integration, in addition to terrorist attacks perpetrated by jihadist groups. The measures adopted to end marginalization are accompanied by security policies that seek to prevent terrorism. Religious freedom is limited by actions aimed at guaranteeing public order. In fourth place, and finally, we can mention states that held colonial empires that ruled over a large population of Muslims during the 19th and 20th centuries. Very early on, these countries welcomed immigrants from their colonies as blue-collar workers. Countries such as United Kingdom and France have the largest Muslim populations, settled for more than a century. They have also suffered the worst and cruelest acts of jihadist terrorism on their soil. It is not surprising that they have an extensive and long tradition, diverse in its case, of measures related to integration and public security. We can see that the answers to the issue of Muslim integration in Europe, conditioned by the sociological situation of each country, vary around 3 categories that can be graduated from a low level to a high level of intervention by the state, in question relating to the status of Islam and therefore the religious freedom of the Muslims. Those states with assimilated historical minorities or with a minor presence of Muslim immigrants tend not to adopt special measures. They guarantee the common status of all recognized denominations and the general protection of the right to religious freedom. Finland, Sweden, Lithuania, Czech Republic, Portugal could fall into this group. Second place, states with a large population of Muslims that deal with integration and security problems tend to maintain a general or a specific regime that guarantees Islamic communities an acceptable status of freedom, while they have also adopted measures for public security and the fight against terrorist jihadism that affects some aspect of Muslims' religious freedom. Germany, Italy, Spain, United Kingdom, for example. And finally, there are states that in some way consider Islam incompatible with national principles and values. For this reason, they adopt various policies that discourage their presence in the country or that seek to assimilate them through coercive actions to those opposed values of national identity. In the case of France, whose policy has influenced other countries such as Belgium, the state uses public policy to try to protect secular values of the Republic in the face of religious communitarianism and the self-marginalization of Islam. Laws such as those prohibiting Islamic headscarf in school or burqa in public spaces seek to put an end to visible symbols that are the product of this communitarianism, or in an effort that encompasses in a general way the creation of a French Islam that accepts republican values, President Macron proposed the law to reinforce national principles approved by the National Assembly. These are measures taken in addition to those of security adopted to prevent terrorism. At the other extreme, and generally promoted by right-wing anti-Islam parties, the nationalist policies of states such as Bulgaria, Poland, or Hungary can be mentioned. The values of the Christian tradition of these countries are especially reaffirmed, values into which, in their vision, Islam does not fit well. This way, Poland and Hungary's refusal to accept the Muslim immigrants who would correspond to them according to the quotas set by the European Commission are justified. Within the general framework in which Muslims' religious freedom is ruled by those states where they maintain an important presence, characterized by the title of this presentation as being somewhere between religious freedom and security, we will later refer to some relevant aspects in the exercise of their beliefs. An especially sensitive question for the Islamic communities settled in Europe is that of the construction of mosques or prayer centers. It is in these places of worship that not only are religious meetings held, but also that Islam is taught and aid to families in need is channeled. In most of the countries with heavy Muslim immigration, planning and construction of mosques has caused more than a few social problems. The mosques do not have access to funds for renovating or conserving buildings of cultural interest, since the majority of them have been built in recent times. That's the small quantity that, for example, the British Council of Muslims received for this purpose, or a 2005 Belgian law withdraw aid to Islamic mosques. Thus, they depend mostly on private donations. With regard to this, there is obvious reticence when the mosque is financed by foreign countries, particularly Saudi Arabia, that retain ownership of them. This fact was highlighted in the paper presented by France. The Reinforcing the Republican Principles Act aims to better control these donations in order to limit the alleged ideological influence of foreign states on the organization of the Muslim communities. In the past, some countries, such as the Netherlands, did turn to public funding in the construction of Islamic mosques, given the pressing need resulting from the immigrant population. In other countries, such as France, funding was limited to the maintenance of buildings already in existence, but this clearly benefits established churches, but not new religions. But we must not forget the importance of the surveillance of mosque activities in order to control the Muslim population. It has been especially intense in countries such as Great Britain, Germany, and France. This includes control of mosque goers and the funds the mosque receives, and even adopting the extreme decision of closing some mosques. Forenaud, in the French report, emphasizes that the Marseille Mosque at Sunna was closed by a prefectural decree because, and I quote, "the place disseminates ideas inciting hatred and discrimination contrary to Republican principles, likely to promote the committing of acts of terrorism." End of the quote. Other spheres of Muslims' religious freedom where we can find measures that guarantee the free exercise, but also the ideological control of Islam in the West, related directly or indirectly to security, are implemented through public promotion and economic subsidies. These include government financing of the training of imams. The concern of governments regarding the education and preaching carried out in the mosque and prayer centers has proved to be directly related to terrorist attacks. And we must not forget, for example, that Barcelona's massacre in 2017 was directed by the imam of the mosque of a village of Girona called Ripoll, leader of a terrorist cell where several young people with Moroccan roots were radicalized. This concern has led to the possibility of creating schools or colleges where imams can be trained using legal and economic aid provided by the government. Through agreements with Islamic representatives, Holland, Belgium, Austria, and Finland, public authorities have found a way to both avoid the rise of radical Islam and encourage the social integration of Muslims by offering bachelor's and master's degrees in Islamic theology in public university. In France, while the laïcité regime of the 1905 law prohibits public funding of any religious teaching, the non-application of the law in the region of Alsace-Moselle is used to fund a school of Islamic theology for the training of future imams. Another issue that worries European governments and which falls somewhere between respecting the right of religious freedom and the guarantee of public safety is the appointment of people who will carry out the work of religious assistance or teaching of Islam in schools. Regarding this issue, the prevailing tendency is the inexistence of financing of personnel on the part of the public administration. In the first case, that of religious chaplaincy, Islamic chaplains paid through public money are either few in comparison with those of traditional churches, as in the case of Great Britain and France, or in other countries, the law does not provide for these chaplains as it does in the case of Christian chaplains. And this is the case of Italy, Malta, Slovenia, and Poland. The same conclusion can be reached in the case of Islamic religion teachers paid for by the state. Those cases when this service is provided for by government law, the difference between the funding which goes to traditional churches and that which goes to Islamic communities, as well as the number of teachers for one or the other, is considerable. Security measures are also projected in the case of the election of the person who provides religious assistance or teaches Islamic religion classes. Regarding religious assistance in prisons, in most of the countries of the European Union, the prison's prior authorization of the imam who is to provide it is required. And in education in general, the states are vigilant with regard to content and teachers. Also, in some countries, the election of the teachers is mixed up with foreign policy. One example can be seen in Germany. As Muslim associations are defined by the regional or national origin of their members, The largest Muslim association, the ITIB, is controlled by the Turkish Directorate of Religious Affairs, Diyanet. German authorities insist on the independence of German schools from foreign state interference. So, some Länder, for example, North Rhine-Westphalia, have introduced Islamic advisory councils to decide on the religious content and the teachers who will teach Islam. The Länder are represented in these councils and also control the Muslim representation. The right to nominate requires an agreement between the Länder and the Muslim Association, and the agreement may only be conducted with Muslim associations that meet certain requirements, such as independence from another state. In conclusion, adapting to the present of Islam, considered in all its dimensions, cultural, political, religious, remains one of the main challenges facing European society. As occurred in the past with the status of the Catholic Church for the countries of Central or Southern Europe, or the measures adopted regarding cults or sects, today the position of Muslims constitutes a true touchstone of the breadth of the exercise of religious freedom in a country. Broadly speaking, European countries regulate the issue by trying to reconcile security and religious freedom. There is no doubt that the policies of control and surveillance of Muslims have affected and continue to affect the autonomy of Islamic communities. In particular, the policies of those countries that, invoking historical and cultural values from their past, reject Islam as a whole, as a religion incompatible with the West. This leads me to make two final remarks. First, I believe that the statement of the absolute incompatibility of Islam with Western democratic values, basing it on the Quran text or the radical and fundamentalist tendencies, is only a partial view that denotes prejudice. All religions could then be declared incompatible with Western values as well. But we can find many examples of violence and intolerance in the Bible, such as the death sentences for homosexuals or adulterers. And secondly, the importance of a religion, of Christianity, as a historical and cultural element of European society, without doubt, should be distinguished from the values and principles on which pluralist democracies are based. Among these values is that of religious freedom, which, due to its scope, extends to the exercise of all religions, also to Islam. Thank you very much for your attention.
Thank you very much, Professor de la Calle, for this very rich and panoramic presentation of the diversity that exists within the different European countries, but the issues are the same, so we have to find the policies. We are running out of time already half an hour. For this reason, I'm going immediately to the next speaker, that is the most sophisticated Mufti of the city of Didymotiho, the region of Thrace, in the region of Thrace, Mr. Hamza Osman, who will speak us about the application of Sharia in Thrace. Thank you very much.
Dear guests and participants, the Muslim minority in Thrace is the only explicitly recognized minority in Greece as religious under Article 45 of the Treaty of Lausanne. It numbers about 120,000 people according to the latest census. The care and effort made by the Ministry of Education and Relations for the more complete education of Muslim children remains high in the priorities of the Greek state. This is not limited to announcements and declarations of goodwill, but is reflected in the funds allocated annually for the running costs, repairs, and extensions of minority schools. There are currently 235 primary schools, minority primary schools in Thrace, where teaching is conducted in Greek and Turkish. In Xanthi and Komotini, there are 2 minority junior high schools and secondary schools with a mixed teaching system, Greek and Turkish, which are housed in buildings provided by the Greek state. Another development in the field of secondary education took place in recent years, when by legislative regulation the 2 seminaries, madrasas, of Komotini and Xanthi became equal to the ecclesiastical high schools of 6 years of study, and the Pedagogical Institute of the Ministry of Education prepares their program. In Greece, the Mufti is appointed in accordance with the law that defines the qualifications, the process of appointment and termination of the Mufti, his official status, his duties, and the rules of operation of the Muftis. A hierarchical clause, fatwa, in Islamic law stipulates that in a non-Muslim country, the Mufti may be appointed by the state as long as it does not interfere with the religious customs of Muslims. An additional reason for the appointment of the Mufti by the administration is that he exercises certain judicial duties in matters of family and hereditary law concerning the interpersonal relations of Muslims. In Thrace, Sharia, the holy law of Islam, is applied to Muslims by the Greek state. The application of Sharia concerns only the family and hereditary law, and not the criminal law that is valid throughout the Greek territory. The law is enforced by the state as defined by the Islamic religion, but also by the Treaty of Lausanne. For this reason, the Greek state is obliged to have public officials for this purpose, the Muftis. In December of year 2018 was issued the decision of the European Court of Human Rights on the compulsory application of Sharia. This is the holy Islamic law in the Muslim minority of Thrace on issues related to the regulation of family and hereditary relations. Greece is the only country in Europe to which Sharia is applied compulsorily until the recent enactment of law number 4511 of the year 2018. The European Court of Human Rights emphasized that Sharia applies to both England and Wales, but on a non-binding basis only if it is not contrary to national law. The first law for the year 2018 was published in the government newspaper, the law number 4511 of the year 2018, for the amendment of Article 5 of the Legislative Content Act of 24 December of the year 1990 on Muslim religious officials, which was ratified with article only of law number 1920 of the year 1991. The law, after its vote, was characterized as a historic step, predict the restriction in the application of Sharia because of the recourse to the Mufti for family matters such as weddings, divorces, etc., now will be optional. In particular, according to the explanatory memorandum, the parties will be brought under the jurisdiction of the Mufti if both parties submit a relevant request in front of him for the resolution and solution of a specific dispute, always according to the Holy Muslim law. At the same time, law number 4511 of the year 2018 provides that the hereditary relations of the members of the Muslim minority of Thrace are regulated by the provisions of the Civil Code, unless the holder draws up before a notary a declaration of last will in the form of the public will with the exclusively content of his explicit desire for the inheritance to be subject to the Holy Muslim law. This statement is freely revocable, either by a subsequent statement to the contrary before a notary or by drawing up a letter will in accordance with the terms of the Civil Code. Simultaneous application of the Civil Code and the Holy Muslim law to the inherited property or to a percentage or to certain elements of it is prohibited. With a presidential decree in recent years, 6 years ago, the Department of Introductory Direction of Muslim Studies was established at the Theological School of the Aristotle University of Thessaloniki. The establishment of this department in Greece was already very late because in many European countries there have been departments of Islamic studies for many years in order to study Islamic theology and Islamic sciences. The operation of the Department of Muslim Studies in Thessaloniki, in addition to teaching Islam to non-Muslim students, also contributes very positively to its teaching to the children of the Muslim minority community who were deprived of the study of Islam in their homeland for many decades and were forced to immigrate to the abroad to Islamic countries to study Islamic theology. They are now being offered the opportunity to study Islamic sciences near the area where they live and thus be fully trained in the Islamic religion to fill the positions of religious ministers in the mosques of Thrace, which number more than 250 mosques. It is a huge contribution of the Greek government and state to the scientific training of religious educators, most of whom are graduates of Thracian seminaries, madrasas, and do not have degrees in theology. In this way, there will be the appropriate staffing of the mosques of Thrace with highly qualified and well-accepted staff of the Muslim faithful of the Muslim community. Based on my experience as a lecturer in the Department of Muslim Studies, whose curriculum is well-versed in all the scientific fields that cover all the subjects about Islam and its sciences, I firmly believe that the students who will graduate from this department, except that they will acquire the necessary supplies that will help them in their professional life, additionally will have the appropriate knowledge of their religion that will make them true believers as the Islamic religion advocates and demands. Thank you for listening to me patiently.
Dear Mufti, thank you very much for your significant contribution to the European Consortium for Church and State Research. And now we are going to our third speaker, Professor Niels Valdemar Vinding from the University of Copenhagen. Please.
Well, thank you very much for the invitation to present a few short remarks here Thank you to the Consortium and thank you to the organizers. It's a huge pleasure. I initially wanted to consider this issue across Europe and have been digesting the wonderfully profound national reports for this purpose, but for 15 minutes I'm reducing my scope even further. Just see if this works. It's a long-standing academic tradition with the Consortium to do these very wide and very sort of rich, detailed reports, and I can't do it justice in 15 minutes. However, I look to Europe from a particular Danish position, and I hope you'll indulge me. I try to do so for good reason. Now, Denmark, it seems, has very much become a case that draws negative attention to itself in this area. And I sort of highlight some of these trade-offs in the focus of our research. Recent legislation passed through the Danish parliament demonstrates to me, in terms of the interpretations of the exercise of religious freedom, the wanting empirical validity of the underlying ascriptions and the wanting proportionality of restrictive legislation, to quote former UN Special Rapporteur on Freedom of Religion and Belief, Heiner Bielefeld, who's warned against this in the international law commentary on this subject. Now, Dr. Bielefeld obviously knows what he's talking about, and the reason that I say so is because he actually did a mission to Denmark to study some of these aspects, and he published it in the report that I'm citing here. He went to Denmark from 13 to 22nd March of 2016, and while his report is general and touches upon a number of aspects of freedom of religion and belief in Denmark, Dr. Bielefeld looks particularly at the special challenges faced by Muslims and issues of potential discrimination of Muslims in Denmark. And I shall return to some of the examples. If we speak very generally, Muslims in Europe enjoy rights and freedoms of religion and belief, as most of the country reports do testify. And I shan't bore you with these, as most of you are very familiar with this kind of baseline, if I may say so. And frankly, while the fact that people enjoy freedoms and celebrate their beliefs is a good thing, it's legally and sociologically speaking not as interesting as where sort of the topics get hotter. So despite all these sort of ideas, and I've listed different sort of trends that I've seen, this was what my sort of a full presentation, full paper would be. I quickly move on to those two Danish cases. Yes. These particular issues are issues where the Danish evidence is significant, but which also have distinct parallels all over Europe. And they are, as you see, the limitation of religious symbols in both legislation and courts, but recently with the express wish to limit or ban burqa, niqab, face veils, and so on. Such limitations, the Danish case tells us, are difficult to implement. The use and accountability of ordre public arguments or limitation clauses and the argued or perceived anti-democratic sentiments of Muslims in Europe is the second idea. This is often discussed in terms of secularizations, but politicians are struggling with framing the legislation within a human rights framework. Now, these two are just examples, but more broadly, the issues that I listed on the other slides can be said to be interrelated and could be well argued as aspects of one another. Many of the examples one might list are backed by a growing number of national and international court cases, and they're hotly discussed, but they're particularly telling for these wanting empirical validities and proportionalities. And to my argument, and you'll see this in a minute, the power of perceptions of Muslims on the basis of legislation is significant. Now, some of you might be familiar with this. It's something that I outright stole from the internet. I haven't done it myself. Dark red indicates, of course, fuller ban. The light red, a local ban, and the orange bits, partial bans. And Denmark counts itself in the dark red club, as you can see here, where it's stated most clearly, I think in the French case, no one may, in public places, wear clothing that is designated to conceal the face. And Switzerland joined the club in March this year. Now, let's see if this is right. I guess so. On 31st May 2018, a majority in the Danish parliament adopted a ban on face covering, which in effect is and has been discussed as a ban for wearing the niqab or the burqa. The ban, which amends the Danish criminal code, comes after renewed discussions that have been going on, I guess, for 10 years at least. In 2010, the debate quieted down after an academic report had concluded that this was regulating a maximum of 100 to 200 women who wore the burqa or niqab. The amendment was enacted and took effect of 1st August 2018, and to this, during the first year, a total of 23 fines were issued. So it's a law that's been used, and I'll come to this in a minute. In the preparatory remarks, the Ministry of Justice discussed how freedom of speech and freedom of religion and belief came into consideration. And I'm quoting here, to the extent that covering the face in itself is regarded as an expression of opinion, it may be protected by freedom of speech. This should be included in the assessment of whether the cover serves a qualifying purpose, and this is sort of the cog in the wheel that everything turns around. Similarly, it will be included in the assessment whether covering the face takes place in a way and in a concrete context closely related to the exercise of religious freedom. And there you have it, closely related to a specific religious act of worship, I guess you'd say. Outside such concrete contexts, including on the bus to the mosque, it doesn't suffice to refer to the face covering for religious reasons. Now, this commentary by our ministry is quite clear that the circumstances in which the ban applies are limited, or rather that there is express freedom of religion in these particular contexts. And there's considerable rule for interpretation by the individual police officer. And this is, in my mind, what makes this amendment to the criminal code very interesting. The commentary and subsequent instructions to police officers about what these qualifying purposes mean includes fancy dress parties, freedom of speech events, freedom of religion, and particularly in the case of worship. However, it's left up to the individual officer to assess whether or not this is in fact a criminal matter or whether it's a matter for the social services. If the police suspects that the person wearing the niqab or burqa is subject to negative social control, for example, in connection with breach of the ban, because the person, for example, expresses compulsion or other sorts of pressure to wear this face-covering clothing, then the police must investigate it or as a criminal, assess whether or not to investigate as a criminal offense or to help and offer support and so on. Clearly, and this is supported by legal and sociological research on interpretive symbolic interactionism, as it's called in fancy terms, the interpretations of what these symbols mean are at stake. But the remarkable setup here is that while Parliament has been discussing this for 10 years or more, they can't agree what this face ban actually means, and neither can their legislative council, but they nevertheless leave it to the individual police officer to make the call. Now, this isn't just a testimony to the inability or the inadequacy of the political arguments behind the law, but it really is passing the buck, as the Americans would say, to the individual police officer in the field. And guess what happens? They approach this with a very lenient, very hands-on strategy. This is from the actual day of the amendment taking effect, and these burqa niqabi dressed women were demonstrating their freedom of speech against this law. And she was in a terribly distressed state of emotions, and so this inclusive police officer decided to give her a hug. She was doing her job, but she was indicted into the special police investigation by members of parliament for doing this on this exact day. Now, let's go to the second bit of it. These, in Denmark, and this is the case of how the constitutional interpretation is actually changing in recent years with these 10 or more amendments to different legislation in Denmark. These bills have all incorporated a requirement that religious communities and preachers and so on must work for equality, democracy, and rights and freedoms, and against subversive institutions and negative impact on social cohesion and public order. This is an elaboration on the constitutional freedom here, the so-called limitation clause in the Danish constitution. Citizens shall be at liberty to form congregations for the worship of God in a manner which is in accordance with their convictions, provided that nothing contrary to good morals or public order shall be taught or done. Now, in his report, Dr. Bielefeld criticized the unqualified understanding that hold all Muslims accountable for the actions of an extreme few, conditioning the free and peaceful existence of freedom of religion by Muslims, which includes the right to construct and maintain places of worship, on the behavior of an extremist minority within Islam is unacceptable. Most critically, however, Dr. Bielefeld emphasizes the hardline and overzealous political and legislative responses to religious extremism as the most explicit threat to freedom of religion and belief in Denmark. While extremism does warrant a clear political response, the harsh rhetorics and the legislation targets all Muslims. Leading members of parliament have even suggested to reinterpret and tighten this limitation clause that I showed you just before, which states that nothing at variance with good morals or public order shall be taught or done. Now, and Bielefeld's comment is this: he warns that such a legislative move would be out of line with the international governing understanding of freedom of religion and belief, and he wrote about that in the book from 2016 also, by giving legislators free and uncontrollable means of eliminating or marginalizing basic human rights, and therefore isn't justifiable at all. And he says that such an interpretation would limit freedom of religion and belief, and also threaten to strip Muslim communities of their achieved status position in Denmark, or develop new tools for controlling religions, particularly Islam. I'm just at the core of it. Now, this was 2016. He'd written the huge tome on this, and he'd done his country report, and what does Denmark do? Well, they proceed to enact even further implementations of this. This is another amendment to the Danish Criminal Code that makes it illegal, and this is where we need to sort of keep very tight these categories, because it's not a straightforward exercise, to making it criminal to expressly approve certain criminal acts as part of religious education. And a long list of such criminal acts are listed in the code. The wording is particular, as incitement to hatred or to violence, for example, is already a broadly established criminal offense, and much of political establishment have a champion, so to speak, freedom to speech as an absolute right. Now, they're motivated in this legislative move in an attempt to counteract behaviors that undermine Danish laws and values and support parallel legal beliefs by criminalizing the explicit denial of the existence of certain criminal acts as part of religious instructions. And so they proceed to argue that it safeguards public order and can be implemented. Now, this new article in the criminal, just a minute, in the criminal code, apply expressly to religious education alone and not to other forms of education or influence. It's understood as tightening of criminal law regarding religious preachers only, who, in the logic of the amendment, have a special authority over congregations, especially, I guess, children in situations where they might be very impressionable. However, it doesn't apply to others in such impressionable situations, in others with special authority. Religious preachers and others who provide religious education speak from a general point of view with a particular insight and authority in relation to people who must be considered to be particularly vulnerable in one way or the other, and vulnerable to this kind of influence. And so the legislative logic is that it's particularly problematic if these individuals, through their behavior, counteract and undermine Danish values by condoning criminal offenses. Well, needless to say, the bill was met with significant criticisms. The reasons aren't weighty enough. The Council of the Danish Bar and Law Society, the Danish Institute of Human Rights, a number of independent organizations, professors from universities, all sort of criticized this. And the remarkable thing isn't that they criticized this, but the response of the ministry in continuing with the enactment of the amendment. And this is the argument. Let's just consider Article 70 of the Danish Constitution, which is the sort of freedom from discrimination. No person shall by reason of his creed or descent be deprived of access to the full enjoyment of civic and political rights. That's the key, and I've got the European Convention, Article 14 down there, which is sort of at stake here. Now, and this is my last slide, the Ministry of Justice argued in response to this criticism that it's assumed that Article 70 of the Constitution only prohibits discrimination on the basis of a particular creed. And since the bill must apply for everyone who expressly endorses certain criminal acts as part of religious education, the bill does not raise, in the views of the ministry, questions in relation to Article 70. And further, and I'm jumping down to the last bit of here, according to the case law of the European Court of Human Rights, the provision that persons in comparable situations as a starting point must be treated equally and that discrimination is justified only, and so on. So you know this, they find that it does not discriminate against comparable groups. And here the current argument of the legislature is that the provisions enacted forbids discrimination against an individual on the basis of his individual religion, but allows for a general discrimination of religions, as all ministers of religion are limited in their exercise of this right. Never mind, as I've hinted at already, politicians, media pundits, and others with similar extreme point of views and significant influence on weaker members of the public are not limited by this. So, in light of Article 67, which this amendment sort of feeds into the public order argument, it points exactly to the argument that opens for what we consider in Denmark a shift in Danish constitutional theory regarding freedom of religion, bringing it, as Dr. Bielefeld already sort of teased 5 years earlier, in direct conflict with Denmark's commitments to international standards. And here's the point, and the irony of this isn't lost on you, I hope. The Danish government, in its zeal and moral panic, is limiting freedom expressly in the name of requiring religious groups to work for democracy, equality, and rights and freedom. So that's the sort of long story short. Thank you very much.